Ladies and gentlemen, one thing that we can say for sure when it comes down to the legal system in America, it has never been fair and it will never be ran with a system of justice. One thing we do know, these folks have a serious inability to be fair. They couldn't do it to save their mama's life at this point. So let me get into this story. And yes, you're looking at the Supreme Court. The Supreme Court's latest opinion means innocent people must remain in prison. Well, we already know, just looking at the exonerations, that they don't care about innocent people. And they really don't work hard to get innocent people out of jail. If you are not doing nothing for 20, 30, 40 years, and then, oh, my bad, we put this innocent person in, that's not working hard. Okay, that's not working hard to get anybody out. And just remember one thing, the same faces that are putting you behind bars are the same faces that are working to get you exonerated. It's no victory at all. It's no victory at all. So let's get into this story, y'all. Clarence Thomas majority opinion ensures that innocent people will spend years behind bars. The Supreme Court just ruled that at least some federal prisoners who are completely innocent must serve out their entire sentence with no meaningful way to challenge their unlawful conviction. One of the most fundamental principles of criminal law is that no one may be convicted of a crime unless the legislature previously passed a law making their actions illegal. If there is no law on the books that say marijuana possession is unlawful, then a judge cannot toss someone in jail because they were found with a joint. But let's be real, that's exactly what they do in America. You may have certain things written in your books, but I can tell you, y'all don't enforce everything in the books. Okay. So, but when they write these articles, they write it as if they're following everything to the letter. And we know that's a blatant lie. Okay. They enforce the law if the judge on the bench feel like doing it. If they don't feel like doing it, they don't. And that's exactly how these kangaroo courts work all around this country. So, the Supreme Court 6-3 decision in Jones versus Hendricks, handed down Thursday, does not directly attack the fundamental principle. Instead, it does so indirectly by prohibiting many prisoners from ever challenging their convictions in court. So if you are innocent and you were given a 25-year sentence, they're saying you're going to have to serve out that 25-year sentence. So let's go on. Instead, I read that part. So the case center on Marcus D'Angelo Jones, a federal prisoner who was convicted in 2000 of possessing a firearm after being convicted of a felony. 19 years later, rehab versus the United States in 2019, the Supreme Court held that no one may be convicted under this felony in possession statute unless they knew they had a felony conviction at the time they possessed the gun. Jones said that he incorrectly but genuinely believed that his previous felony conviction had been expunged when he purchased a gun. Thus, his conviction was invalid under rehab. In essence, his claim that no federal law criminalized his possession of a firearm because he did not know he had a felony conviction. Thanks to Clarence Thomas' opinion in Jones, however, we will never know if rehab invalidates Jones's conviction. That is, if he is innocent of the crime that caused him to spend nearly a quarter of a century in prison because the courts held that Jones may not challenge his conviction. The reason why is a federal law known as Section 2255, which originally prevents federal prisoners from challenging their conviction or sentence more than once. So why don't you just say, we don't care if you're innocent, you're staying in jail. We don't care, because that's really what you're saying it, and you're trying to use laws and everything. We know how you feel. After he was sentenced, but before rehab, raised a cloud of doubt over whether Jones belonged in prison at all. Jones successfully petitioned a federal court to vacate part of his sentence. Thomas's opinion hold that Jones pre-rehab challenge to his sentence blew his only chance to challenge his conviction, even though Jones couldn't have known before rehab, uh, which decided that he had a potentially valid claim that he is innocent. Section 2255 contains several exceptions which allow some federal prisoners to bring a second challenge. One which provides that Jones may bring a second challenge if Section 2255's usual process is inadequate or ineffective to the test the legality of his detention. But Thomas construes this inadequate or ineffective language very narrowly, so narrowly, in fact, that the Justice Katanji Brown Jackson mocks Thomas in her dissenting opinion for ruling that someone like Jones may only seek relief if the courthouse where a 2255 motion would have otherwise been filed has burned to the ground or been carried away by a mudslide. So, this is what Clarence Thomas is sitting on the bench doing to ensure innocent people remain behind bars. I mean, he don't work for the community anyway, but this is further proof that he don't do it. He is sitting on that bench working against our people. So, under Thomas's majority opinion, it is not just be people like Jones, people convicted under the felony and possession gun statute, to whom rehab offered new hope, who will be denied second chances at overturning their convictions. These are innocent people. The courts know they're innocent, but they will not be allowed to overturn their conviction and must serve out the full sentence, even though they are innocent. This is what your Supreme Court is doing. This is what they're doing. Many other people who committed no crime whatsoever will also be denied these rare but occasionally legal second appeals and will languish in jail. Now, do you think this has a lot to do with how bad this country looks with all of these exonerations? So, I guess in order to cover up and muddy the waters, you just shut down the exonerations and keep everybody in there and make everybody in there supposed to be in there. We know that y'all couldn't do that to save your mama's life. So it's creating a smokescreen. Oh, well, nobody's getting exonerated anymore, so they're all guilty. Woo! You're gonna fail at this one too, America. You're gonna fail at this too. To understand Thomas's reasoning is helpful to understand the history of how Section 2255 became law. Before its enactment in 1948, federal prisoners who wished to challenge their convictions were required to do so in a federal district. So, where they were incarcerated, this system was unworkable because it placed an extraordinary burden on federal trial courts that happened to be located in the same geographic district as federal prisons. Well, who put something in place that's unworkable? Let me guess, somebody with a high IQ. Additionally, because prisoners are often incarcerated far from where they were tried or convicted, the court that heard the prisoner's challenge often did not have easy access to records, evidence, and witnesses. It needed to weigh the prisoner's argument. Section 2255 fixed the problem by requiring prisoners to challenge their convictions in the same court that originally tried and convicted them. This meant that the burden of hearing the cases, known as habeas petitions, would be distributed among the federal district courts. It also meant that the courts most familiar with the prisoner's case would also hear any habeas suits challenging the prisoner's confinement. Originally, Section 2255 does not allow a prisoner to bring a second habeas challenge if they were previously denied such relief, but the law permits a second challenge to proceed if Section 2255's original processes are inadequate or ineffective to test the legality of a prisoner's detention. Mm, mm, mm. So it goes into other cases that challenge Section 2255 on the basis that the inmate was innocent. And y'all, the bottom line is they're trying to shut down innocent people from getting out of jail. And they have effectively done this. This is what your Supreme Court is sitting around doing. This is what they're sitting around doing. But, it's just like the rest of America. If you think any of their government agencies, these courts, or anything they got set up is going to be fair, they have never been fair. They have no history of being fair. They have no history of being fair because the intent was never to have a fair society. The intent was to have a society that's comfortable for one group and the hell with everybody else. And that's exactly how it's been ran. So, you know, good luck. I sure hope nobody is going in as a federal prisoner and you are innocent. They are taking away, and they have, the decision has been made. They have taken away your right to challenge your conviction, and you're innocent. They're telling you tough luck. You're going to have to serve out your sentence. Too bad. Even if we find that you're innocent, tough. Y'all, please tell me what you think about this story. Mm, mm, mm. Please leave your comment and subscribe. Don't forget to hit on the notification bell, and I'll see you on the next video. Peace, family.